Hi everyone, my name is Reinkeluers. I'm going to be talking about arbitration clauses in employment contracts. And I'm going to start by talking briefly just about what arbitration is, what an arbitration clause means, and then I'm going to talk about the applicable legislation in Ontario, some of the case law, and whether or not these clauses are enforceable in employment contracts, and some suggestions on how to draft a clause that is hopefully going to be enforced by the courts. So just to start with the basics on what an arbitration is. An arbitration is an alternative dispute resolution process. So in other words, it's an alternative to going through the court system in which the parties agree to retain a neutral private third party to render a binding decision. So in other words, rather than going to court and appearing in front of a judge, the parties agree to hire a private individual to sit in and hear their case and reach a binding decision which can be enforced later on in the courts if necessary. Arbitration has been widely used in commercial disputes as an alternative to litigation. It's not as common in employment disputes, but it is starting to become more popular in recent years. And an arbitration clause is essentially just a term in a contract in which the parties agree that a dispute arising out of that contract will be resolved by way of arbitration, not by the courts. So some of the advantages of arbitration: one of the big advantages is speed. The court system can take quite a long time to resolve dispute through the courts, partly because of the nature of the process and partly because there can often be delays getting hearing dates. So arbitrations are often quicker ways of resolving the disputes, both because there can be less delays and also because the parties can agree to a simpler, more streamlined process if that's how they want to proceed. A second advantage is the parties can choose the adjudicator who's going to resolve their dispute. If you commence a claim through the court process, all you know is that you're going to get a judge. And the judge may not necessarily have particular expertise in the area of employment law. If you pick an arbitrator, you know you're going to have a party that has experience in the area of your dispute. Another advantage of arbitration is that it is private, meaning it's not open to the public. The decisions are not publicly reported. So if you are concerned about having negative publicity arising out of your employment dispute, that can be a big advantage for arbitration in those circumstances. Now the private aspect of arbitration can also be a disadvantage because a decision by an arbitrator in a private arbitration dispute does not have any precedential value, meaning that the decision is not reported, and if it's a helpful decision, you can't rely upon it in future cases. So for example, if you're a large employer and you have perhaps multiple employees bringing lawsuits regarding similar circumstances, if you received a favorable decision on one of those cases in the courts, you could rely upon that as a precedent in subsequent cases, but you wouldn't be able to do that in an arbitration. Now another advantage, it can be either advantage or disadvantage of arbitration, is the cost. So in arbitrations, it's typically easier to contain the costs because the parties can agree to set their own process. One of the big aspects of litigation process is what we call discoveries. So in the discoveries, each party has to disclose all relevant documents, and the representative for the party has to attend an examination before the other side, even prior to the adjudication happening. So now that process can take quite a long time and be very time-consuming and expensive in terms of legal fees. So typically not always, but often in arbitrations, parties agree to either simplify or eliminate the discovery process entirely, which can be an advantage in reducing legal costs. But it can also be a disadvantage because then you do have less opportunity to obtain disclosure of the other side's case prior to the hearing. Now, the other aspect of costs for arbitrations is arbitrations do have a higher upfront cost than litigations because unlike the court system where, although there's administrative fees, the judge is paid for by the government and the courtroom is paid for by the government, in an arbitration you have to pay the arbitrator personally and you have to pay for the room where the arbitration is going to take place. So there's higher upfront costs. And again, depending on the nature of the case, the arbitration could be cheaper, could be more expensive, could be about the same, depending on how it goes. So the last aspect that distinguishes it from the court process is finality. Without getting into all the details of the test, arbitration awards are much more final than court decisions. It's more difficult to appeal. So again, that could be an advantage or a disadvantage depending on your perspective and depending on what the result ends up being in your particular case. So in Ontario, the main act governing arbitrations is the Arbitration Act. I've set out a couple of key provisions from the statute defining an arbitration agreement and talking about the Act's applicability. Some arbitrations are governed by a separate act called the International Commercial Arbitration Act, but that won't typically be relevant to arbitrations involving employment disputes. Now, one of the nice features of the Arbitration Act is it provides kind of basic standard procedure that parties follow when they conduct an arbitration in Ontario, but with limited exceptions, the parties can, for the most part, contract out of the procedure set in that act and agree on whatever procedure they want to have to resolve their dispute. And this is a big advantage, in my view, over the litigation process, because if you commence a claim in Ontario, if it's a civil claim, it's going to be governed by the rules of civil procedure, and there's really not much flexibility in, if you don't want to do one of the steps in the civil procedure provide for, that's not really an option. You have to follow the rules as they're set out, whereas in an arbitration, the parties, as long as both parties agree or it's set out in the arbitration agreement, the parties are fairly free to set whatever procedure they want. So the main method of enforcing arbitration agreements in Ontario is Section 7 of the Arbitration Act, which provides that if two parties enter into an arbitration agreement and then one of the parties then tries to commence an action in court regarding a dispute that should be covered by the agreement, the other party can bring a motion to the court asking for a stay of the proceeding. Now, a stay essentially means that the proceeding is postponed indefinitely. So if you have an arbitration contract with your employee and the employee brings a wrongful dismissal case in the court, you would bring a motion under this section and ask the judge to stay their proceeding until it's been heard by an arbitrator. So now I'm going to move on to enforceability of arbitration clauses in Ontario. Now, in disputes between businesses, arbitration agreements are generally enforceable so long as they're clearly drafted and it's part of a binding contract. But the law isn't as simple when it comes to employment disputes. So the leading case in Ontario is Heller against Uber Technologies, which is a decision earlier this year from the Ontario Court of Appeal. Now, just briefly, the facts were that the plaintiff was a driver for Uber Eats, which is Uber's food delivery service. He was earning about $400 to $600 a month while working basically full-time and driving his own vehicle. So he wasn't making a particularly high income. And he commenced a class action on behalf of all Uber drivers in Ontario who were being classified as independent contractors by Uber. And he sought a declaration, among other things, that rather than independent contractors, they were employees and they were entitled to the protections set out in the Employment Standards Act. Now, the contract between Uber and the drivers contained an arbitration clause, meaning that any dispute arising out of the contract would have to be taken to arbitration rather than through the courts. So Mr. Heller had to argue that this clause was unenforceable because that would have prevented his class action from proceeding. So I've put the clause up on the slide here. I'm not going to read through all of it, but some of the key points which I've bolded is that the clause provided that the agreement would be governed by the laws of the Netherlands, that the place of arbitration would be in Amsterdam in the Netherlands, and that the arbitration would be subject to the rules of the International Chamber of Commerce arbitration rules. And those rules for the arbitration are important because under those rules, the upfront cost to commence an arbitration would have been $14,500 US. So the Court of Appeal considered two separate issues in terms of whether or not the arbitration clause was enforceable. The first issue is whether or not it amounted to a contracting out of the Employment Standards Act, and the second issue was whether it was unconscionable, meaning that it was so grossly unfair that it should be set aside. So, and unfortunately for Uber, it lost on both aspects. On the first issue, the Court of Appeal held that the arbitration clause was an illegal contracting out of the Employment Standards Act. So briefly, the reasoning is that the Employment Standards Act provides that any agreement to waive an employment standard that's set out under the Act for the benefit of an employee is void. So in other words, if you have a clause in your contract in which the employee is waiving a right set out in the Act, that clause is void and is not enforceable. Now, one of the rights an employee has under the Act is that if they're alleging a contravention of the Act, they have the right to file a complaint with the Ministry of Labour and that this is separate from the court process. They can file a complaint with the Ministry of Labour, which has to be investigated by an employment standards officer who can render a decision requiring the employer to pay wages or other amounts to the employee if the Employment Standards Act has been contravened. And now in this case, in Heller, the Court of Appeal held that the right to file a complaint with the Ministry of Labour is an employment standard, and because the arbitration clause prevented the Uber drivers from filing a complaint with the Ministry of Labour, the clause was a contracting out of the employment standard, and therefore it was unenforceable. And it's noteworthy to mention that in this case, the Uber drivers hadn't actually sought to make a complaint. It was really just a hypothetical concern. But even in that case, the court still said that that was a contracting out of the ESA, and it was unenforceable. On the second issue, the court also found, independently of the first issue, the court found that the arbitration clause was unenforceable because it was unconscionable. And some of the factors they considered in finding it to be unconscionable, or in other words, grossly unfair, is that it was unfair to these Uber drivers to have to incur the large upfront cost of arbitration, which would have been, again, as we saw previously, at least $14,000, $500 US, plus obviously the travel cost of going from Ontario to the Netherlands for an arbitration, which would have been prohibitive for someone basically earning $400 to $500 a week as a driver. And the court was also concerned that the clause provided that the arbitration would be in accordance with the laws of Netherlands, not Ontario, and there was no evidence before the court as to whether the Netherlands would have the same employment standards protections that employees have under the Employment Standards Act in Ontario. There is also no evidence that the drivers were receiving any legal advice regarding the clause, or that they'd have any ability to negotiate the clause with Uber, given Uber's market power. Now, this case, earlier this year in May, the Supreme Court of Canada granted leave to appeal from this decision. A number of parties have been granted leave to intervene, which means they're parties without a direct interest in the lawsuit have been given leave to make submissions to the Supreme Court on why they think, how they think the case is going to affect the broader public. So this is probably going to be a very watched case, given the number of interveners, and the appeal is scheduled to be heard not very long from now, November 6th. So probably by the time we have our next seminar, we'll have an update on the law in this area. We'll probably have the Supreme Court's decision. So I'm just going to talk now about another case, a more recent case. This is also from 2019. This is the Superior Court talking about the enforceability of arbitration clauses, which follows the Court of Appeals decision in Heller and Uber. Now, this case is Reinhardt and Legend 3D Canada. In this case, the employee worked for a U.S. company, Legend, what I'm going to call Legend US, and he signed several separate employment contracts with them which contained arbitration clauses, pursuant to which the dispute was supposed to be arbitrated in California. Now, subsequent to that, the employee moved to Canada and commenced employment with the related U.S. company. And now that employment, there was no signed agreement or arbitration clause. So the employee was terminated, and he brought a wrongful dismissal action in Ontario. The company sought to have the action stayed on the basis of the arbitration agreement that was signed with the U.S. company. Now, the court analyzed the matter as follows. The first issue is, first of all, is there an arbitration agreement? Second, what is the scope of the arbitration agreement? Third, does the dispute fall within the scope of the arbitration agreement? And are there grounds on which the court should refuse to stay the action? And then that last issue will be where the court considers whether it's unconscionable or whether it violates the ESA. So the court found that the arbitration clause was unenforceable for multiple reasons. The first one is that the court found there was no written arbitration agreement between the employee and the Canadian company. The court found that there was an arbitration agreement between the employee and the U.S. company, but the dispute fell outside the scope of that clause because it was regarding the employee's employment with the Canadian company. So it wasn't caught by the scope of the clause. In addition, the court found that the arbitration clause violated the Employment Standards Act. A big part of the employee's claim was for overtime pay, which is something that's a right that arises out of the Employment Standards Act. And because the arbitration was taking place in was supposed to take place in California, the clause didn't clarify which law would be applied, and so the court was concerned that the arbitration, even though this employee was working in Ontario might not provide them with the overtime pay that they were entitled to under Ontario law, so therefore that would render the clause unenforceable because it would not be giving them one of the employment standard protections that they're entitled to under the Act. And secondly, following the decision in Heller and Uber that because the clause prohibited the employee from bringing a complaint to the Ministry of Labour, that also rendered it unenforceable. And again, the court found this to be the case even though the employee hadn't actually commenced a complaint. There was just a hypothetical fact that they could have, and that was prevented by the clause. So moving on to some suggestions on how you may try to draft clauses that are more likely to be unenforceable. Are more likely to be enforceable. Sorry, I don't want to give you the wrong advice. Now, first of all, I should say that this is just a disclaimer. These are just suggestions. There's no guarantee that this will work, especially given the fact that the leading case is currently under appeal to the Supreme Court of Canada. So, there's certainly a chance. I mean, the Supreme Court of Canada may uphold the Court of Appeal's decision, but they may also change the law substantially. We don't really know until we get the decision. So whatever the law is now may not be the same 6 months from now. So with that disclaimer out of the way, based on how the law currently stands, a couple of my suggestions are as follows. So first, ensure the arbitration clause is fair to the employee. So if the employee is working in Ontario, Ontario law should apply and the arbitration should take place in Ontario. And secondly, a big concern that the court had in the Heller and Uber case is the prohibitive upfront cost to the employee of commencing an arbitration. Again, it was close to $15,000 US plus travel expenses. So in my view, an arbitration clause in an employment contract is more likely to be enforceable when it's in a contract with a senior employee who's earning more, and where the upfront costs associated with arbitration are more likely to not be a prohibitive barrier to the employee in bringing a complaint. Now, my second thought is, again, you want to make sure that the arbitration clause is consistent with the rights guaranteed by the Employment Standards Act. And again, as I talked about before, if an employee is contracting out of or waiving a right provided by the Employment Standards Act, that clause in the contract will be unenforceable, and that includes arbitration clauses. The big issue with arbitration clauses is, so far the courts have found them all unenforceable because they prevent the employee from bringing a complaint to the Ministry of Labour, even though in most cases employees don't actually want to do that because the remedies that the Ministry of Labour can provide are not the same as the court's remedies. In a court, the judge can award wrongful dismissal damages, or damages for human rights violations and all that type of thing, which can't be awarded by the Ministry of Labour. The Ministry of Labour simply awards the employee the minimum rights they're entitled to under the Act, which again are typically much less than they could be awarded to at common law by the courts. So in my view, you should consider setting in the arbitration clause that the employee has the option of either bringing an arbitration or making a complaint to the Ministry of Labour. And so that way, you're not precluding the employee from doing that. And as a practical matter, especially if it's a more senior employee, they probably don't want to bring a complaint to the Ministry of Labour because they won't have the same remedies that an arbitrator or that the courts would provide. And even if they did, it would still provide the employer with a benefit because, again, the remedies are much less than the courts. So that's the end of the presentation. Thank you very much for listening.